4:55 p.m., August 19, 2011, Lawrence Zimmerman calling.
Mr. Hicks.
Hi, this is Lawrence Zimmerman.
Yes, I'm sending an email right now, Mike.
I don't know how much you know. I understand that your office is in Baverman's old office building, correct? He used to have his office right there at the same spot.
Yes, my understanding is he did.
Right. Now, do you know Mark Kadish also? But anyway, so you represent Dennis O'Brien, and you've entered your appearance in already, is that correct?
Well, they don't really enter appearances for your arrest hearings. So, okay. But yes, I've contacted the court to let them know I'm representing you, but it's resolved now.
Okay, well, just because, honestly, I don't know how much Dennis has told you, but I'd still prefer to have something in writing that shows me that you do indeed represent him, and you're just sending me over a quick affidavit or acknowledgement that you represent.
I'm sending you an email right now.
Okay, great. And then, just in generic terms, Dennis C. O'Brien has called me, I think, on 2 occasions. He's never, under any circumstances, called me since July 19th, 2011, when we were before Judge Cooper. That's troubling because there's no communication there. The other thing is I've received threats, and some of them have been including Mr. O'Brien and some activities that he's done, which I think we can go ahead and go into those things tomorrow. But to make me feel a little bit more comfortable, it'd be nice if my own court-appointed attorney would give me a complete copy of my client file materials and information. That's something that I'm entitled to, and the fact that I haven't been given any of this stuff makes me a little bit hesitant to trust them, because obviously if everything's above board, most attorneys have no problem saying, yeah, here's a copy of your file, here's who I've talked to, and here's what's going on. And I've asked him to meet with me and FBI agents and some policemen regarding some of the obstruction of justice, and he's very close friends and acquaintances with some of the people that are adverse parties. So all those things add up to things that clearly, in my mind, show conflicts of interest at a minimum. And really, when somebody's not above board and doesn't want to communicate openly and effectively with you, you always wonder what they're hiding. And hearing some of the things that I've heard out of his own mouth really troubled me. And then some of the things that were shown, I've got the transcript of the last hearing before Cooper, and I've compared that with Dennis O'Brien's actual words, and they don't add up. So all those things really are troubling. And again, Dennis O'Brien, before July 5th, I didn't know him. My concern is what he's done after July 5th. I just don't understand why Dennis would take their side over mine, especially when he's supposed to represent me as an attorney. So it's an awkward position, and we'll see how it goes. But as a very first step, sending over that information, the client file, would be a good step in good faith going forward. And then hopefully we can talk later tonight or tomorrow.
You mentioned that, and I will talk to Mr. O'Brien.
That would just be the discovery from the government. That wouldn't be who he's talked to. It wouldn't be the notes he's taken. It wouldn't be the name of his investigator. It wouldn't be the name of his paralegal. It wouldn't be the name of the witnesses he's talked to. It wouldn't be any additional information, client calls, investigators, forensics, nothing. And I don't understand why he's so aggressively trying to defend his friend. And I'll tell you unequivocally, with evidence that I have, he hasn't represented my interests. We're not going to go into any more.
I'm curious, so what makes you think that's an arrestable offense? Don't you have to take up the State Bar of Georgia?
Nope, because when there's crimes against you and you get threats and there's actual Georgia crimes, then I think it's appropriate to bring criminal statutes there. He's had the opportunity to reverse his criminal actions, and he hasn't. I'm not going to go into the details. Like I said, let me go ahead and verify who you are, and it's good faith. And you know as well as I do, I'm entitled to my client file and materials. So as a first step, why don't you do that, and at least then it'll show me that in good faith he's trying to do it. Now, since July 5th, he hasn't done it. Now, so there's no questions. It's probably better that he scans them, gets them as a PDF, and emails it to me. And that way, if he emails it to me, there's going to be a paper trail of what he actually sent me. So there will be no question of...
I guess my question, why would he have your file when he was appointed
their attorney wasn't even on the habeas case. The habeas case didn't get opened up until after Dennis O'Brien was appointed. I'm actually appointed Dennis O'Brien against my will because I've asked to proceed pro se. So Dennis O'Brien is on my case against my will. And there's plenty of evidence that shows that Dennis O'Brien knows I want to go pro se, and he has never once advocated for that position.
I'm going to ask Mr. O'Brien, but it concerns me that a lawyer make threats. So Mr. O'Brien is threatening you.
Listen, we're not going to go into this any further because, again, how do I know who you are? I mean, you could be anybody, so until I know for sure and have confirmation.
You're smart guy, Scott. You'd already looked me up and already knew the building where Baverman used to be.
Right.
So I know you've already figured out who I am.
Yeah, I know who you are, but again, I have no idea if you represent them, and I've been lied to by attorneys, and because of the level of this investigation, the people that are involved, including federal judges, and the amount of money, and I'll tell you unequivocally, Dennis O'Brien's had the opportunity to do the right thing, and he has not done the right thing. So if he's being honest with you, great, and if he's not, then, it's part of your duty to know your client.
So, if I get you the file, you'll agree to drop this whole thing?
I mean, obviously, I'm entitled to that, so that's not even a deal breaker or maker right now. I mean, I'm entitled to my entire client file, materials and information, so that shouldn't be real difficult, and again, that's neither a deal maker or breaker, but it obviously shows a step in the right direction as far as good faith.
Well, I mean, you said that you got a lot of other things on your plate, and you'd rather not deal with this, so I'm trying to figure out.
Well, here's the thing.
It's Friday at 5 o'clock. How do I make this go away? So we're not wasting our time, and you're not wasting your time.
Well, get that stuff over to me ASAP. It shouldn't be that hard. If this is a high priority on his plate as well, and for him never to call me back, never to reply to important emails, never to give me a complete copy of my client file, and to send me things that in my opinion are very threatening to me and to my case is unacceptable. But again, that's his decision, so hopefully he'll make the right decision. Hopefully he'll start abiding by the law and by the state bar ethics, and he'll get me those client materials as soon as possible.
So once he gets all that to you,
and then me and you can talk in earnest about how to go with this.
Forget me and you. I'm talking about once he does all that stuff and tells you he's not going to associate all those other people, will you let him represent you, or are you still want to represent him?
At this point, he's got clear conflicts of interest. There's too much bad blood under there. I mean, and for him never to call me back, never to reply to important emails, never to give me a complete copy of my client file, and to send me things that in my opinion are very threatening to me and to my case is unacceptable. But again, that's his decision, so hopefully he'll make the right decision. Hopefully he'll start abiding by the law and by the state bar ethics, and he'll get me those client materials as soon as possible.
So once he gets all that to you,
and then me and you can talk in earnest about how to go with this.
Forget me and you. I'm talking about once he does all that stuff and tells you he's not going to associate all those other people, will you let him represent you, or are you still want to represent him?
At this point, he's got clear conflicts of interest. There's too much bad blood under there. I mean, obviously his interest is to defeat the claims I brought against him, which would mean that he'd have to try to discredit me. And if his interest is to discredit me, that's obviously in conflict with what my interest would be for my case. I mean, please explain to me how that's not a conflict of interest.